what I'm going to try and do today is to, in part, tell the story of land law reform in Kenya in the 2012 period. And it seems to me that that story is really a story about how not to do land law reform. And having told you a little bit about how things played out in 2012 and why I think there were many very concerning failings in that process, I'll try at the end to draw out some lessons, some broader lessons that we might take from the Kenyan experience for Kenya, but also perhaps more widely for the region. In April 2012, Kenya became the latest of many East African countries to approve new land laws. Tanzania, Uganda, Mozambique, Rwanda, Somaliland, South Sudan, and Zanzibar had all introduced new laws in the era of land law reform that commenced in the early 1990s. And there was considerable optimism in the run-up to 2012, that this represented a historical moment when Kenya's system of land relations, which had been at the root of violent conflict throughout the nation's colonial and post-colonial history, could finally be overhauled. The optimism was the result of two significant achievements. First, the approval of a national land policy in 2009 after a long struggle. And secondly, the embedding of land policy in the 2010 Constitution of Kenya, in what is described as the Land and Environment chapter of the Constitution. Preceding that, a number of key events led to the new land laws. These included the publication of the Commission of Inquiry into the illegal and irregular allocation of land, so widely known as the Dungu Commission after its chairperson, and the publication of the report of the Commission of Inquiry into the post-election violence, the 2007 general election violence, the Waki report. Both of these reports fundamentally affected the process of discussing and debating land law reform and what it might look like in 2012. So when the Land Registration Act, the Land Act, and the National Land Commission Act received presidential assent in 2012, in some ways it was seen as the end of a decade of debate and activism about land law reform. But on the other hand, this also marked the beginning of new struggles over access to land, state authority, and debates about democratic accountability. As commentators have pointed out, the process of converting informal policies, land policies, into concrete land laws was bound to be fraught with difficulties. And the starting point for my analysis today is John Harbison's observation that the Kenya constitutional moment appears to have privileged national level procedural and deliberative democracy as the source of substantive democratic land tenure outcomes, and by extension the terms in which Kenyans relate to each other and to their rulers. The process of introducing and debating the proposed new land laws was fraught with difficulty and in many respects was disappointing. I won't go here into an account of the very difficult passage of the legislation through Parliament. I should just comment that the way in which the land reform process played out provided citizens with very little meaningful opportunity to express their views of the impending changes. Given the importance attached to land law reform by the Constitution and by citizens, the approval of the legislation was characterised by very little debate or disagreement between or amongst legislators. Neither the parliamentary committee charged with overseeing the new laws nor members of Parliament more generally offered very substantive comments or suggestions or debated the substance of the proposals. The land bills, far from reflecting the national land policy and giving flesh to the land and environment chapter of the Constitution, seemed almost entirely disconnected from them. In spite of the constitutional and political implication of this problem, their passage through Parliament was, I think, surprisingly smooth. It was marked by a certain degree of passivity, I think, amongst members of the National Assembly. As such, the new laws can be viewed as a disappointing outcome of at least a decade's struggle over land policy. As Edward mentioned, the work that I did on this process in Kenya arises from my participation in a consortium on land research in Kenya, which was coordinated by the Katiba Institute, founded by Yash Ghai. And the consortium came together in the first instance to try to ensure that the draft bills were made available in the first instance for consideration, which was in itself a battle, and then to try to promote debate on that legislation and to provide detailed commentary on the proposed bills. And the most important task that we were faced with was to try to review the extent to which the bills were in line with the provisions of the 2010 Constitution. It's important to point out that the Constitution specified a time frame within which certain key pieces of legislation must be enacted on a range of different issues. It required that land legislation should be enacted by Parliament within 18 months of the promulgation of the Constitution. As a consequence of this provision, the outer time limit for enacting land legislation in Kenya was the 27th of February 2012, by my calculation. The 27th of February. On February the 15th, and again on February the 22nd, the Land Bill, the Land Registration Bill, and the National Land Commission Bill were given their first and second readings before the Kenyan National Assembly. In the run-up to those readings, academics, commentators, and members of civil society, including Yash Ghai, Jill Ghai, and myself, really struggled to find and read drafts of the bills. Various websites had versions of the legislation posted up on them, but it was far from clear that these were the latest or the most reliable versions of the legislation, of the proposed legislation. When these were finally released by the government printer on February the 22nd, the very day that the Committee on Land and Natural Resources held its first consultative meeting with the public, most people who attended that session, including the Kenya Human Rights Commission, the Kenya Institute of Surveyors, the Land Sector Non-State Alliance, Actors Alliance, the Kenya Private Sector Alliance, hadn't had the benefit of reading the newly published draft bills. Neither, indeed, had members of the committee themselves, as they openly admitted to us. It was widely recognised and stated publicly by many groups at the meeting that the drafts of the bills failed to enact the Land and Environment chapter of the Constitution. A number of groups pointed out that as they stood, the bills failed the test of constitutionality, a powerful claim in the wake of a recent audit by the Commission for the Implementation of the Constitution, which had reported that many of the laws approved since the promulgation of the Constitution didn't pass this test. Yash Ghai, commenting on the draft bills, pointed out that they did not remain faithful to the national land policy, neither to the Constitution. But the Commission for the Implementation of the Constitution issued a statement that the bills, to the largest extent possible, conform to the Constitution. Many individuals and groups who spoke at the committee hearings and in the media about the inadequacy of the drafts recommended that the bills be withdrawn altogether and that more time be given for revision. That was resisted both by the chair of the Land Committee and by the Minister of Lands. In the event, on March the 9th, so very, very close to the deadline, the National Assembly voted by the needed 2/3 majority to delay the final vote on the constitutionally mandated legislation by a further 60 days. At the time, the Katiba consortium worked hard to try and draw attention to some of the shortcomings in the draft bills. And in a foreword written by Yash Ghai, we tried to make broader points about the enactment of laws to implement constitutional values and objectives. And at the time, Yash wrote, "The practice so far has been to issue bills without any useful explanation of what policies are being implemented or how. The people are confronted with lengthy legal texts, for the most part badly drafted, often copied from the laws of other countries, often with internal inconsistencies or inconsistencies with other legislation. And this has been particularly the case with the land bills. It's impossible for most Kenyans, including lawyers, other experts, ministers and parliamentarians, to understand the content of the bills, especially since, unlike the Constitution, the drafting style is complex, convoluted and old-fashioned. This effectively prevents the participation of the people in lawmaking as required by the Constitution." Just to finish the story, if you like, the proposed amendments to the land bills were presented to Parliament, came available on April the 16th, and it was immediately apparent that what was being proposed was not in any significant sense a revision or a redrafting, as had been widely called for, but rather were really very brief amendments to the three pieces of legislation. The bill was largely unaltered. Many of the issues that we had raised, many of the concerns that we had raised, remained unaddressed. Nevertheless, the three bills reached the committee stage in Parliament and shortly thereafter were approved. The legislation, in other words, came about as a result of an extremely flawed process. And it seems to me this story it really is an account of how not to do land law reform. I'm going to try and, I think, now explain why I think the process was flawed in the way that it was. A striking feature of the months leading up to the approval of the new land laws was the setting of specific time frames for the enactment of the new legislation. And that time frame was used in discussions with us as a way to rush or to foreshorten debate. And it's difficult to say whether, looking back, whether that was, to what extent that was a deliberate strategy and to what extent it came about by accident. Because as Hornsby reminds us, Kenya's history suggests that there are no easy generalizations about the intertwined challenges of politics, development, security, and national identity. Accident and design intermingle. What is clear is that by invoking the deadline, the constitutional deadline for the legislation, space for detailed consideration of the proposals was always limited. Those who argued for strict adherence to the constitutional deadlines maintained that a failure to do so would lead to the dissolution of Parliament. Those who didn't think adherence to the deadlines was necessary countered that the land bills were an important set of laws and that it was unlikely that Parliament would be dissolved for taking time to consider the proposed laws in detail. What we see here then is an ironic use of one part of the Constitution, the mandated deadlines, to defeat another part of the Constitution, the important principles in the Constitution about deliberation and participation in the process of lawmaking. Now, clearly the achievement of the national land policy and the land chapter of the Constitution can be credited to a large extent to civil society activists who worked hard to expose and define Kenya's land problems. As Harbison recognises, it's in large part due to such efforts, the 2010 Constitution went beyond guaranteeing respect for civil and political rights to ensure that social and economic and cultural requirements and roles within the Kenyan state be constitutionally recognised and upheld. At the same time, at least some of the explanation for the failure to translate these achievements into concrete laws must, I think, be sought in the sphere of civil society. In fact, many land-related civil society groups seemed unwilling to challenge the retreat into technical legal responses by some individuals and groups, and seemed unable or unwilling to show how the process of drafting laws is itself highly political and contested. A constant refrain heard during the public meetings of the Land Committee was that the laws were highly technical and complex. This claim, as well as the imposed time limits, seemed always to be deployed as a strategy to foreshorten and to limit citizens' participation. Now, this is a tendency that's been noted elsewhere. Patrick McCausland, writing of Tanzania, for example, has said, in his experience, to move from policy formulation to drafting laws is not, as some people assume, to move from a debate on policy to one on legal technicalities. The move changes the context of the debate, but it remains nonetheless a policy debate. How ideas are turned into practice, into powers, duties, limitations, restrictions, when it becomes clear who wins and who loses out, the objections are never on policy grounds, but on technical legal grounds. A particular clause won't work, or a certain provision is unnecessary, or another provision goes too far. The response of civil society groups involved in land matters in Kenya, it seemed to me, was not to try to challenge that claim about the technical nature of the proposed laws, but rather to accept them. And to some extent to reinforce that approach. So far from seeing the ways in which technical legal claims are themselves political, Kenyan civil society accepted their position as necessary, in fact, didn't just accept their position, but created for themselves a position as necessary mediators between the people and the law. Now, distrust of bureaucratic power over land is widespread amongst citizens, as analyses of land grabbing in Kenya have shown, and Edward has alluded to some of those ongoing problems of land grabbing. The allocation of public land has long been exercised by successive presidents and their land commissioners in pursuit of political patronage and personal accumulation. The new land laws were widely seen as an opportunity to address those problems, to redress Kenya's grossly skewed structure of land management and end predatory land practices by the state. But the achievement of that aim would have required civil society to wrest control of the debate from bureaucrats, to see the process of discussing proposed new land laws as a political and not simply as a technical exercise, to resist the rush to legislate, and to make real the Constitution's promise of participation by the people in major policy changes. It also seems to me that the legislation with which we are now faced is not redistributive, or has not been. Its aim never was to be redistributive of land in either its intention or its effect. There is a distinction between what may be called deep redistributive land reform, the aim of which is to change the nature and foundations of land ownership by redistributing land, for example, from the wealthy to the poor or the landless, and shallow redistributive land reform, which is concerned solely with land administration and aims to wrest control over land from a centralized and corrupt state. In their intention, Kenya's new land laws were redistributive in the latter sense rather than in the former. They challenged bureaucratic power rather than the structure of land holding. In general, the 1990s witnessed a global intellectual climate in which the formalization of land tenure went hand in hand with the promotion of the rule of law. And it's crucial to point out that the emphasis on land reform, of land law reform in Kenya, foreclosed debates about redistribution. David Kennedy, the American legal scholar, has argued that there is an unarticulated hope by those who seek to work within a strictly legal framework that law can substitute for and avoid confrontation with perplexing political and economic choices. Scholars, practitioners have placed law and legal institution building, the techniques of legal policy making and implementation, the rule of law, broadly conceived, front and centre, and in so doing have excluded rather than encouraged contestation over economic and political choices. And debates over land law in Kenya have taken place within those strictly prescribed parameters, with an intellectual formation that predisposes them to embrace ideals of the rule of law and administrative justice over substantive redistribution. Civil society groups proved ineffective in revealing the political import of the final stages of the land reform process. And it's clear that at the level of process, the debate surrounding the new land laws failed to engage citizens in any meaningful way. It was conducted largely out of public view, in closed workshops, and almost entirely neglected, and was entirely neglected by the media. Now, this is not especially novel. Lack of consultation has dogged many African countries debating new land laws over the last 2 decades. The difference in the case of Kenya is that the country had embedded the principle of participation and procedural fairness in its 2010 constitution, and citizens' hopes in this regard, both generally and in relation to land issues, are high. Kenyans in the front line of opposition to authoritarianism who joined the struggle for democratization viewed the promulgation of the Constitution in August 2010 as radical and transformative. In particular, the promise of the Constitution to address long-standing grievances over land has meant that land promises and constitutional promises have become intertwined in the minds of the people. According to this reading, the constitutionalizing of matters of land tenure has in a sense raised the stakes. Disillusionment with the failure to resolve Kenya's land issues runs the risk of spilling over and being perceived as a failure of the Constitution itself. Now, those of us who listened to Yash Ghai speak last night remember that he said it was too early to judge the Constitution and its success or failure. But I think in relation to land, the danger is that the constitutional promises over land that are now embedded in the Constitution and which people have embraced and to which people are attached have wide implications for the constitutional project, the transformative project as a whole. I hope that when he speaks, Yash will tell us a little bit more about recent developments to amend some of the 2012 legislation and to enact new legislation, for example, on community land. The discussion of land laws is ongoing in Kenya. There is now, I believe, an omnibus bill doing the rounds. And Kenyans, it seems to me, will soon find that they have yet more land law. To adapt the words of Upendra Bakshi, Kenyans were looking for land justice. Instead, they will find that they have only land laws. And I'll leave it there.